Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Today we have another one of those lawyers behaving badly, and this one is a prosecutor, a female prosecutor, who didn't do her job. Let's talk about it down at the beach. It is indeed funny sometimes how one situation will lead you to compare perhaps another situation. And recently, in doing my research for my annual CLE, I found a really interesting case out of Wyoming. Let's take a look at it. So, this is a cautionary tale, and it may sound very similar to another case we've been discussing on this channel. Leanne Manlove was admitted in Wyoming in 2000 and about 19 years later was elected as the prosecutor in Laramie County. And in fall of that year, less than about 9 months after she started, the first signs of trouble started as the staff began reporting their concerns to Bar Council. And then in December of 2020, the circuit and district court judges wrote a letter to the bar reporting Manlove's conduct. They said they had witnessed her refuse to fulfill her ethical obligations and that the judicial code of conduct required them to report her. Now, you know it's gotten bad when the judges in the district and circuit courts write to the Bar Council and say, hey, you guys need to do something. Their concerns were her personnel management and her abdication of professional responsibilities. So, when the Bar Council got this, they immediately went to the Supreme Court and said, hey, you need to suspend this gal. But the Supreme Court said, no, I don't think so. I'm not really certain I understand why it is that the Wyoming Supreme Court did not go ahead and suspend her when they were asked to suspend her, because clearly in her role she has an impact on and can tremendously affect the safety of the community. But for whatever reason, the Supreme Court did not do that, probably because she was elected to office. So the bar continued to investigate, and in June of 2021, they filed their first formal charge. And then in October of that year, they filed their second formal charge. Those were consolidated, and in March of 2022, they held a hearing panel. It went out over 8 days, and the panel recommended that she be disbarred from the practice of law in Wyoming. Well, what did she do? What did she not do? Well, first of all, RL was charged with a crime of moral turpitude, let's say. And as a result of that, he was charged with as a habitual criminal, meaning he'd done this a lot. Manlove arraigned him, and the district court ordered them to exchange discovery. Now, there's nothing unusual about that. In fact, it would be unusual if it didn't happen. There is always an expectation that courts will expect the prosecutor to give over the Brady material, as well as anything else that the defendant has a right to get. So the defendant complied and made a request, and the prosecutor complied with what she had, but she did not turn over the DNA evidence immediately. In March, she went to a scheduling conference, and in that scheduling conference, she says, hey, I've got the DNA, but I haven't provided the results yet. So RL's counsel asked to move the case back to June, and he got that ruling. And then, month before trial, RL's counsel gets the discovery disc, but not what's called the litigation support package. So he files a motion to exclude. So one of the things that every lawyer knows, because you've been in a courtroom, hopefully, everything's written down. There is a record made of everything that's said. So when this gal tells the judge, hey, I've got the DNA evidence, but I haven't finished going through it, I'll get it to him pretty soon, and then later on says she did not get the DNA information, that's a pretty serious case of somebody just not telling the truth. And it's obvious to me that she's not telling the truth in that regard. So she provided the test results, but not this litigation support package, which is what kind of machines were used, who the analyst was, what their analyst training was, when were the machines calibrated if that's necessary, and that sort of thing. So in June, the court holds a motion on a hearing to exclude. She blames the police. Manlove blames the police and says she doesn't have the litigation support package because they didn't provide it. But it's been sitting on the server for about a month now. So she admitted she had a duty to provide it, but said she would just dismiss and refile the case. So she dismissed the case the next day, and she asked to dismiss it without prejudice, meaning it could be refiled, but the court granted the dismissal with prejudice. And in looking at that, the hearing panel found a violation of Rule 1.1. Rule 1.1 requires a lawyer to provide competent representation. And they also found a violation of Rule 1.3, diligence. Rule 1.3 requires a district attorney to act with reasonable diligence and promptness in prosecuting, investigating, and representing the state of Wyoming in all criminal matters. As a district attorney, she was obligated to know and comply with timing requirements and the applicable criminal investigation and prosecution rules in a criminal matter. It is fairly rare for a lawyer to get hit with a violation of Rule 1.1 competence. The whole reason that lawyers take a bar exam is to demonstrate that they are competent on the law. But when you do things that indicate either that you do not understand the law or that you simply refuse to follow the law, then you can certainly be sanctioned under Rule 1.1. And as to Rule 1.3, it is not uncommon to see lawyers get dinged for diligence. A lot of times, particularly people who have large numbers of cases, they often get hit for diligence concerns because they do not routinely get things moved down the road the way they probably should. So that I'm less concerned with the diligence issue than I am the competence issue in this particular case. She had an affirmative duty to learn of favorable evidence in the state's control and divulge that evidence to the defendant. That's her Brady requirement from Brady versus Maryland, a Supreme Court case. And when he filed a written demand for production, she should have gone through an exercise of due diligence to find out what she had, but she didn't do that. And because he was charged as an habitual offender, she should have filed the evidence of his prior criminal records, and she should have provided a list of witnesses who could testify about that. One of the things I think people don't fully understand with regard to trial work is that courts don't take anything for granted. And when you charge somebody as an habitual criminal, you have to bring in certified copies of the judgments of conviction for the multiple convictions upon which you rely. And in addition to that, you have to turn those over to the defense, because what do we know about criminals? They routinely lie to their defense counsel. Oh, no, I've never been busted before, except that when they get the information from the prosecutor, whoa, there's the 15 times that they've been to jail or prison in the last 10 years, and that certainly doesn't make them look good. Well, if you're going to charge somebody as an habitual offender, or if somebody has been charged that way, as this gentleman was, you better be prepared to prove it, and you better bring the receipts. She didn't, and that was a huge oversight on her part. Fairness to opposing counsel. Ms. Manlove's failure to timely disclose evidence also violated her duty to be fair to opposing party and counsel. She can't knowingly disobey an order or an obligation from the court, and knowingly denies actual knowledge, and the hearing panel found that she knew, she just didn't do. And then they hit her with a duty of candor. They said, a lawyer shall not make a knowingly false statement. And she did. She said it was the crime lab's fault, when in fact all that information was actually sitting on a server in her office. And her email statements contradicted her based on what she had said 2 months earlier. Shakespeare said it best, "Oh, what a tangled web we weave when first we practice to deceive." People are generally bad liars because they can't remember the lies that they have told. But when you tell somebody, well, I didn't get the DNA evidence when it's been sitting in the system for months, and when you mentioned it at an earlier court date, that just, I mean, that's a stupid way to get caught lying. It is really the truth that it is better to tell the truth and let the chips fall where they may than it is to do something like this and lie and get caught. So she lied to the disciplinary hearing panel, and they found that her testimony was inconsistent with her statements to the district court. Once you're in front of the disciplinary panel, the appropriate approach is mea culpa. I didn't mean to do it. It was a mistake. What you don't want to do is lie. You don't want to compound your problems, particularly if one of the things you're being accused of is lying. If you lied then and you lie again, no one is going to believe you when you claim that you are not lying. And so that's one of the big mistakes this gal made, is she just continued to lie, thinking, I guess, that she would always get away with that, when clearly she wasn't always going to get away with it. She affirmatively misled the court and the district hearing panel about what the Cheyenne Police Department did and what her ability to get the DNA was. And then there was a second matter, which also involved the abuse of a minor in a particular way. A 14-year-old girl. The police investigated in October of 2020. The detective had the report done by November of 2020, and nothing has happened. So the report and the detailed interviews were uploaded to the server in the DA's office. The report noted the DNA evidence collection in October. The crime lab uploaded the results. The detective uploaded her report, and she had access to all of that. But in spite of that all being done by February of 2021, she didn't do anything on the case until June of 2021. And basically what she did was she called the detective and said, "Hey, I need to talk to you." And then before the detective could call her back, she wrote a memo saying, "At this point, I'm not able to charge this case. I'm going to return the affidavits and wait to hear back from you on the evidence that I do not yet have." That same evidence that was actually sitting on her server. One of the problems underlying this case is the DA had a combative relationship with the police departments. And there's no reason for that. I mean, they're on the same team. And the last thing in the world you want to do as a prosecutor is make your police mad, because they're the people who bring you cases and who make sure that the evidence is there so that you can prosecute. Now, that doesn't mean the police don't make mistakes. It doesn't mean that DAs don't make mistakes. What it means is the way to prevent mistakes is to have a good relationship with the police so that they know what you want and need. And apparently that just never reached the forebrain in Ms. Manlove here. If all the digital forensics are complete, assuming they corroborate the victim's statements, can you please include that evidence in a new affidavit? And without waiting for the response, she then declined the next day. So she attempted to defend by saying that this was an exercise for prosecutorial discretion. The girl's mom did not have anything to do with that. She went and filed a complaint with the bar. Declining a charge when you have good evidence, particularly in a 14-year-old who was a victim of a special assault, I think you have to be really careful about doing that, because it makes you look really, really bad. And indeed, this so upset the girl's mother that she filed a complaint with the bar, as she absolutely should have. So as I said, she said, "Look, I have prosecutorial discretion. I decided in my discretion not to prosecute." And basically what they said was, you can't escape accountability for a charging decision when an attorney acting in a civil context would face disciplinary action for the same conduct. So they found clear and convincing evidence of violations of duties under Rule 1.1 and 1.3 of Wyoming's rules, in that she failed to take action for months. And then, as I said before, she made false statements in the disciplinary case, and that's where you knowingly make a false statement, and knowing requires you have to have actual knowledge. We find Manlove's statements that she was wholly reliant on law enforcement to notify her of DNA test results were materially false. Again, I can't say it often enough. You just can't lie in a disciplinary hearing. You can't lie to the district court. You can't lie to the circuit court. You can't lie to the disciplinary panel, because if you do, you're going to get caught. And she did. The hearing panel also found that her conduct in these matters violated Rule 8.4, which is conduct that is prejudicial to the administration of justice, by a number of other things, but among them, timely filing the criminal charges and issuing a materially misleading press release. The hearing panel found that she violated her duty of competence under Rule 1.1 and 1.3 in the second case. And then the third issue was her mass dismissals. At some point, because she lost a lot of her staff, she only had a few staff members left. Now, initially, when she took office, there were 4 open positions. The previous administration had 9 positions, but 3 of those left, so there were 6 attorneys left in the DA's office. She fired 5 of the 6 and brought in 4 new hires. So she went from having 6 attorneys down to 5. That was a terrible decision on her part. Apparently, she wanted to bring in her own staff, people, I guess, that she thought had a high opinion of, thought they'd be good prosecutors. But it would have made a lot more sense to hire those 4 new people and add them as additional staff when there were only 6 people in the office to begin with, so that you could come up to the full number of prosecutors, and retain the staff that was there so that they could hopefully mentor them. But instead, she got rid of these prosecutors, and as a result, her output and her clearance rates suffered. So the former office manager described the place as being in chaos. Where have I heard that description before recently? Let me think. There was a hostile work environment. According to the people that she worked with, the environment working there was very hostile. And a lot of times when things are going badly, people do become hostile. And unfortunately, that is a very common character flaw in attorneys. So Manlove was told by the governor that she needed to cut her budget. But then when they looked at what she had spent and the number of prosecutors that she had hired, they said, nah, you don't need to implement your budget cuts. But she took that as an opportunity to change her office from a full-service prosecution to a felony only. So you can't do that, because you're charged with prosecuting all of the crimes, not just the crimes you want to prosecute. So she told her staff to cut cases. She said, you can keep up to 75 of the cases on your docket. I'm going to dismiss the others, so find the cases you want to prosecute, and I'll dismiss the others. Beginning in October 1, she dismissed several hundred cases in the busiest criminal jurisdiction in the state of Wyoming. And they were fully aware that the statutes required her to have a prosecutor in the treatment court. She also was aware that she had to prosecute a first offense DUI, which she declined to prosecute. And when she filed her motions to dismiss, she always cited that they were without prejudice because of the budget. The idea that you could legitimately become just a felony-only prosecutor's office, that is such a bad idea. There are a number of DAs who have done that, but generally speaking, they're in much, much bigger areas than Cheyenne, Wyoming. I don't understand why she thought she could get away with this and what she really thought she would accomplish by doing it. And blaming it on the budget when there was absolutely no issue with the budget is really a pretty silly idea. So the Supreme Court found violations of Rule 1.1, 1.3, 3.3, 3.4, 8.1, and 8.4 for her acts or omissions in the State versus RL, and her criminal action in the other case involving the minor who was assaulted. And they said that prosecutors are held to an even higher standard of conduct than other attorneys because their unique role is to ensure justice for the public. Multiple violations, each and every time, all these violations are accompanied with misrepresentations and lies. And that is not a good look for anybody who's trying to keep their law license. So after reviewing all of these violations, they found the presumptive sanction for Rule 1.1, 1.3, and 8.1 to be disbarment. Disbarment is the presumptive sanction. When disbarment is the presumptive sanction, the only way to escape disbarment is to have a great deal more mitigating factors than you do aggravating factors. You see this a lot in substance abuse cases where somebody gets in trouble because they're drinking too much or doing drugs. A lot of times you will see the mitigating factors of drug abuse, seeking treatment, that sort of thing, go toward the issue of making it less likely that they'll be disbarred, maybe getting them a 1, 2, or 3-year suspension as a result. But here, the violations were numerous. They were accompanied by basically flat out lies, and the aggravating circumstances certainly outweighed the mitigating circumstances, and ultimately that's why the presumptive sanction was disbarment. And with regard to Rules 8.1 and 8.4, they found the presumptive sanction was disbarment. They wound up disbarring her and ordering her to pay $32,000 in costs. That should be a tremendous cautionary tale for any prosecuting attorney who essentially cuts her staff and decides not to prosecute cases and then throws her staff under the bus. Not that I'm mentioning any names. You know, they say that doing the same thing over and over again and expecting a different result is the textbook sign of being a little bit nuts. And unfortunately, I think sometimes people get locked into patterns of behavior that perhaps they've gotten away with all of their life. And then they get to a place in their life where they have reached a status of being in power somewhere, and they think that it is wise to continue the same habits that got them there in the first place, which may have included, mendacity. Irrespective of that, what you have in a situation like this one, and it's very sad because this lady went to law school, she became an attorney, she went to serve her community, and then when it came right down to it, she was incompetent to do that. She didn't understand how the system worked. She didn't bother to find out. She had a contentious relationship with her police department, and as a result of that, cases fell through the cracks. Criminals were let go. There were numerous cases that were dismissed that should never have been dismissed. And I suspect that the district attorneys that worked in the office, the assistant prosecutors, were probably just shocked that this woman would deliberately dismiss people who were serious criminals and serious crimes in an attempt to become felony only. Now, I don't know what this Manlove's, I don't know what her political affiliation is, and it's not really relevant. But I can tell you that when you have a situation where you can't fix the problem, where you have either personnel issues or other things like that, and this is true irrespective of whether you're a district attorney or somebody who runs the night shift in a hospital, what you have to do is you have to find somebody who can get you the help necessary to get the problem fixed. Because you're in charge of fixing the problem doesn't mean that you alone have to fix it. It means you can engage consultants, you can talk to people, you can ask for advice. She could have sat down with any one of those district or circuit court judges and asked, what am I doing wrong? How do I fix this? Tell me what I should do and help me do that. But instead, what she did was she just kind of put her head in the sand, it looks to me, and didn't do what she was elected to do, which is protect and serve her public by putting bad people behind bars and protecting good people. Now, it is a sad tale in America right now that there are prosecutors who believe that that's their job, to protect the criminals from the normal people in society. And that is perhaps the worst thing that has happened in the last couple of years. I hope that there is a trend toward, seeing less of that, but I'm not certain that's the case. At any rate, I hope you have found this an interesting discussion. It will be one of the signature cases that I talk about on my continuing legal education seminar, which deals with attorney ethics. I didn't bother to mention that all of those rules that were cited were bar rules. That code, the model rules of professional conduct, those guide both the lawyers in their daily practice, but they also guide the courts in how they administer discipline. And I may have said it earlier, but one of the things that courts talk about is that discipline is not there to punish the attorney. It's there to protect the public. The punishment to the attorney is only incidental. And basically, the punishment is there to get their attention and bring them back on the right side of the law. There are some cases, however, where it's fairly apparent that you're not going to be able to bring them back on the right side of the law. And I think this was one of them. So that's what I have for you today. Please go out of your way today to do something nice for somebody. There are multiple opportunities to do that, whether it's holding a door open for someone if you've already walked through it, or handing the homeless guy at the corner $5 if, or a can of tuna or something like that. Do something nice for somebody. You will feel so much better about yourself when you do that. Thanks again for watching. I will catch you down here at the beach next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.